Good morning, good afternoon, good evening, wherever you're joining from in the world. My name is Emil van der Does. I'm the coordinator for the Stolen Asset Recovery Initiative, the World Bank and UNODC's joint initiative. And I want to welcome you to this launch of the second edition of the Asset Recovery Handbook, one of our flagship publications that has been used a lot over the last couple of years. We launched the first one about 10 years ago, and at that stage, people weren't particularly interested in the publication. We didn't make a lot of fuss around the publication. A few people were interested, a few people were there, but nothing like the interest that we are getting today. If we see what has happened in civil society space, if we see what the ICIJ and others have turned up in terms of corruption scandals and how much more attention there is to this issue, and if we also see what's happened in the international arena and how the G20 and the G7 are giving enormous importance to the issue of anti-corruption and asset recovery, and how indeed also for ourselves at the World Bank and the IMF, anti-corruption issues are becoming very prevalent in our operations and becoming much more part and parcel of development work. So the issue has really risen up the international agenda in the last couple of years, and that is very heartening to see, and it is great to see so many participants here today to be here at this launch. And you confirm indeed that that the importance of this topic for us. The book itself deals with all the different stages of the asset recovery process, how you need to make sure that the domestic cooperation system is well in place, that the different parts of the system internally work well together, how to make sure that you cooperate well internationally, informally, formally, how to make sure that you have a good seizure and confiscation regime. And so there are many different parts of the puzzle. And the panelists here who have joined us today will be looking at those different parts of the puzzle and will each treat different parts of those puzzles. Let me now introduce the panelists here that we have here today. We're very fortunate to have, it said, by the way, it said on the invitation, it said we would have Hermione Cronje. She was unable to attend because of a family event at the last moment, but we're very lucky that Willy Hofmeyr, Special Director, former Special Director of Public Prosecutions at the Asset Forfeiture Unit in South Africa, was able to join in her stead at the last moment. Thank you very much, Willy, for joining at such short notice. Willy's a bit of a legend in asset recovery land, so that's great to have you here. We also have Dan Clayman, Principal Deputy Chief of the International Unit of the Money Laundering and Asset Recovery section of the US Department of Justice, has responsibility for litigating and supervising asset recovery cases since before the inception of the DOJ's Kleptocracy Asset Recovery Initiative in 2010. And Dan was also one of the US negotiators on Chapter 5 of the UN Convention Against Corruption. Chapter 5, of course, on asset recovery, the topic here today. Then we have from the private sector, because that's an angle that is often forgotten, we have Rodrigo Castellan, an asset recovery attorney from the private sector who is particularly adept at using insolvency procedures to go after the proceeds of corruption. He's the founder of the Brazilian Institute of Asset Recovery, IBRA, and is leading and has led lots of multi-jurisdictional asset recovery litigation cases. And then finally, we have Laure du Castillon, delegate magistrate at the Belgian Ministry of Foreign Affairs, at the Directorate of Multilateral Affairs, and she is the focal point for anti-corruption evaluations of the OECD, for the Council of Europe, and for the UNCAC. We will have the panelists speaking in 2 rounds in a moment. The first round will look more, will be more sort of diagnostic. What are the challenges at the moment? Where are things not working particularly well? And then a second round focusing more on what are the good practices, what is going well, what are some fruitful ways of overcoming those challenges. 2 housekeeping points at this stage. For your questions, please use the chat box to the right, and you can direct those questions to all panelists or to those specific as you wish. At the end of the session, I will be asking each of the panelists for one measure or one reform which they think would really make a difference when it comes to international asset recovery. I would also welcome attendees and participants to put forward, their one idea, and then that is something that the panelists can also respond to. And a final point to remind everyone here that this session is being recorded. With that, before we jump into the panel itself, I want to give the floor to Jean-Pierre Brun, the lead author of this publication, to thank a few people, but also to communicate a few of the main ideas of the book. Jean-Pierre, you have the floor. Thank you.
Thank you very much, Emile. Good morning, good afternoon, and good evening to all. And a great thank to our distinguished panelists for being with us today. We are very proud and happy, as you said, to have so many participants, so much interest. I see already almost 200 attendees. We have around 500 people registered. So we are very proud and happy for this interest. And I will also extend my thanks to all the colleagues who have helped us draft, review, and launch this 2nd edition of our Asset Recovery Handbook. I should here mention Larissa Gray, Kevin Stephenson, and Clive Scott for their role in the 1st edition, specifically in 2011, and also Anastasia Sotiropoulou, who joined the team for this 2nd edition. Also, I want to express my gratitude to all the experts inside and beyond the Stolen Asset Recovery initiative team who have contributed in these last months to this update, which is a lot of work. And beyond them, let me say that the real authors of this book are the hundreds of practitioners from all over the world who every day are building asset recovery practices. And this is my first remark. Asset recovery depends, successful asset recovery depends above all on all the colleagues who every day detect, investigate, prosecute, adjudicate corruption cases. This work is extremely demanding, complex, challenging, often frustrating, and sometimes even dangerous. The role of the World Bank UNODC STAR initiative is to tell them that in spite of all these challenges, they are not alone, and that success is possible. In the last 10 years, many countries have demonstrated indeed that success is not easy to achieve, but again, that it is possible. And I will try to highlight shortly 4 of the lessons that were learned from some successes in the past 10 years. First lesson from these past 10 years. To have a chance of success, jurisdictions must mobilize and coordinate all their relevant investigative and prosecution resources. Too many jurisdictions fight corruption in silos with limited exchange of information between agencies. A more coordinated approach pays off, including in the context of international cooperation and investigations. And examples in Tunisia and Malaysia illustrate that this approach can help. Second lesson of these last 10 years, choosing the right legal avenue and using creative mechanisms are key. It means sometimes that civil proceedings can be a complement and also sometimes an alternative to criminal action. Civil proceedings can be non-conviction-based confiscation. It can be also civil lawsuits, and it can be also insolvency proceedings. So that's the first idea in this second lesson. There is another idea in this second lesson about creativity and choosing the right avenues. And the second lesson is, and the second idea is that new frameworks that help shift the burden of proof from the state to the defendants, to the investigated persons, are also extremely important. And they are illustrated, for example, by the legislation of unexplained wealth orders in the United Kingdom. Third lesson learned, going after and this one is extremely important as well. Going after enablers can be a game changer. Intermediaries, including sometimes banks and law firms, are involved in corruption or money laundering schemes. Targeting prosecutions or lawsuits against the facilitators can bring huge rewards for the states that are seeking redress. It has been illustrated very recently in the Malaysian case. And last and not least, fourth lesson, civil society plays an increasing role not only in advocacy by advocating for asset recovery, but also in the conduct of asset recovery cases. In recent years, CSOs, NGOs have provided treasures of information that have triggered law enforcement action, and they have also brought cases to court. So they have been actors of the asset recovery process. There are many more lessons that we could draw and that are described in our work. We have tried to describe them, to capture them as much as possible. We hope that it is not finished, that even more creative and even more effective methods are going to continue to emerge in the coming years. But what we hope is that this effort to update our asset recovery book will help practitioners in their daily practice, and that it will help also policymakers establish the right legal frameworks for asset recovery. Because our book is mainly a call for action, finally. So I am, and because it is a call of action, I am now very happy to leave the floor to our colleagues, practitioners. Thank you, Emile.
Thank you very much, Jean-Pierre, for those opening words. And let me thereby open the panel and turn to our first panelist, Willy Hofmeyr from South Africa. Willy, you've been instrumental in setting up the system for asset forfeiture and anti-corruption within South Africa. And I was wondering whether you could share with us a few of the sort of challenges you face in doing so, and altogether the challenges of having an effective domestic cooperation system. Willie, you have the floor.
And it's a real pleasure to spend some time with my colleagues from all over the world. Yeah, we sort of had a slightly incidental start to asset recovery. We have about
Sorry, I can't hear. Willie, can you
check my
Yeah, now I hear you again.
microphone?
Yeah, I can hear you.
The sort of initial thrust for law enforcement came from our law commission in South.
Willie, again, we can't hear you. Technicians, is there anything we can do with establishing a phone connection for Willie?
South Africa.
Because I can hear the beginning.
Let me just check if is this better? I'm just switched from my phone to where it says speaker.
I can hear you now, yes.
Okay, so I don't see any pictures anymore, but I think you can probably hear me better.
Yes, I can hear you, yeah.
So yes, so the initial proposal for some form of asset forfeiture came from a body called the South African Law Commission that sort of does research on international legal trends and made a proposal that the form of asset forfeiture should be introduced in South Africa. At the time, it was very much based on the then British model. But when the proposed legislation came to Parliament, I was at the time a member of Parliament on the Justice Committee. We sort of did some research about what happened internationally, came across the American system of the non-conviction based asset forfeiture, as it is called now. And so we introduced a combination essentially of the British system, which is conviction based, and the American system, which is non-conviction based in South Africa. I think for me, some of the big lessons that we've learned over time in setting up an effective asset recovery capacity was firstly that it is a complicated terrain. In many cases, the traditional law enforcement society groupings, the prosecutors and the detectives, didn't really much believe in this asset forfeiture stuff. And so we had to play quite a big role in convincing, engaging with our colleagues elsewhere in law enforcement and persuading them that it's worth devoting some of their resources to something that they didn't see as their core business at the time. I think things have changed quite a lot since then. But I think one of the important things that we were able to do was essentially the asset forfeiture unit is based in the prosecuting authority. And we managed to persuade the police to second certain people, a number of people, essentially semi-permanently, to work with us at the asset forfeiture unit. And that is vital because we didn't have any investigative powers. I think some of the newer units now have investigative powers, but we were very reliant at the time on law enforcement to do that part of the job for us. And I think we learned from that cooperation is absolutely vital with other people in law enforcement, but also more widely. So we sort of analyzed some of the government departments that had the bigger corruption problems and persuaded them as well, essentially our budget was very thin at the time, but essentially to pay us to deal with some of the corruption problems in their departments, and obviously the money that we recovered, we paid back to those departments. So it was a long time now, nearly over 20 years ago. I think there's been a lot of developments in the law internationally since then, but at the time, we basically used a combination of the then British system, the conviction-based system, and the American non-conviction-based asset forfeiture that basically relied on showing that the assets themselves are tainted in the sense of being either proceeds of crime or assets that have been used to commit a crime. So I don't know, I think I should probably pause there because I just wanted to give a quick overview of our system and how we got to where we are today.
Thank you very much, Willie. Let me turn to Dan. Dan, as a prosecutor in the US system, you are responsible for a lot of the big anti-corruption cases. And I was wondering whether you could talk a bit about the importance of your own domestic system on freezing, restraint, and obtaining final confiscation orders, and how to deal with ultimate disposition and return. And again, focusing in this first round predominantly on the challenges and the roadblocks that you faced in that. Dan, you have the floor.
Sure. Thank you for the chance to speak. And, let me first say, I hope everyone's taking precautions to keep themselves and their families safe during the pandemic, especially as we move into an important holiday season for so many people. I also want to congratulate Star on this latest contribution. Star has really been a leader and a great partner to so many nations and practitioners over the last 10 years. And this latest update to this important volume, I think, is terrific. As a practitioner, I think it goes without saying that, I'm going to recognize some of the difficulties that I've encountered in my experience or from some of my colleagues. But even within the U.S. government, there may be multiple different perspectives. And so I'm happy to offer a couple of ideas, but they're certainly not universal. I would say, focusing on some of the challenges, there are maybe 4 areas that I would highlight. First off, all cases are dependent on evidence. And in these types of cases, evidence of the underlying corruption, I think historically has been the most difficult thing to gather, particularly because cases are now so much transnational in nature. And so in order to be successful, you need the evidence, and establishing the relationship or nexus between the corruption and the assets or the criminal actors or both is paramount. And it's always going to be a challenge in these cases. I think a second area that I think historically has been a major issue is the legal framework. There are in many countries, I would say universally probably, very strong presumptions in favor of property rights. I think you could make an argument that sometimes the procedural protections for property rights are even greater than the procedural protections for protecting someone's liberty interest. And so there are those are a serious issue that I think has to be considered as we try and balance the interests of the state in recovering the proceeds of corruption with third-party rights. And of course, also in the legal category are differences in legal systems and communities and things like that come up. A third area that I would mention is that these cases are very resource intensive. And that perhaps goes without saying as well, because the duration of some of the cases goes on and for years sometimes, and there's a lot of complex issues both to the underlying crimes and to unraveling the asset structures. And then the fourth area that I would say that's a significant historical challenge is coordination and cooperation in transnational investigations, building trust and overcoming sometimes even corruption within the investigating authorities. And these, I think, as appropriately is set out in the volume that we're here to celebrate today, play out differently at different stages of the case, or the sort of the lifetime of a case. In the restraint phase, which I think is really emphasized in Chapter 5, speed and preservation of the assets and their value are paramount. And as well as trying to sort out some of the issues like asset management. How are you actually going to maintain the asset during the pendency of the case? So for challenges at this time, I think evidence, once again, is important, but the burden is lower. And so the focus really is identification of assets and ensuring that there is some nexus that meets the minimum thresholds for restraint. The legal burdens and challenges at this time, I think, are partly trying to accommodate different interests from country to country, or different legal systems from country to country, and also, once again, balancing third-party rights when the government doesn't own them because they haven't been confiscated, with the need to preserve the assets. Of course, here, authority to liquidate assets may be really important as part of the legal structure, because if you don't have that, then the asset can waste even just through maintenance costs, especially if it's a high-value yacht, or it's a high-value vehicle, or a piece of real estate that can deteriorate. Resources in the restraint phase, I think, can be a challenge if you don't have a financial investigative team at the outset to help out with this identification of assets. And if you don't have asset management specialists who can deal with complex assets. Coordination at this sort of restraint phase, I think, is a challenge where evidence is overseas, and you need to understand or have a contact who can explain to you the procedural requirements to restrain assets and help with pre-seizure planning. Again, pre-seizure planning is noted in Chapter 5 too, and can't be underestimated in terms of the challenge that it is. Sort of turning to the next phase, the confiscation phase. Once again, I think each of these four challenge areas are present, but they're in a somewhat different posture. Evidence, I think, at the confiscation phase, globally, people, I think, are getting better at tracing. And so I think that's less of a challenge, but it is still important. But once again, evidence of the underlying corruption is really paramount. And I think there we deal with issues like commingled assets, which again is addressed at some length in the book, which I think is very helpful. But you also have to deal with government secrecy and contracting. How are the assets being bled out of the system? For legal challenges in this area, I think we have to consider what is the appropriate burden of proof and how do we protect legitimate third-party rights. There are sometimes so many procedural challenges that can be imposed that can really delay the process and frustrate an efficient asset recovery. And I think one of the things that we're seeing now with an explosion of more countries being involved in asset recovery and more practitioners out there is a need for stronger measures to be able to enforce foreign judgments, whether it's in a non-conviction based system that that the enforcing country doesn't necessarily have, or whether it's using rebuttable presumptions and circumstantial evidence that the enforcing country doesn't have, but being able to try and recognize rather than duplicate the whole underlying case. Again, resources, always important. Here, I think one of the challenges that we see is with some of the bigger cases, not only are you going to have translation and accounting and basic database management issues, which all cost money, but I think we're also seeing civil litigants who may be turning to contingency fee arrangements where that means defense counsel has no limits on their ability to challenge procedures, and no matter how frivolous the assertion. And then when it comes to coordination and cooperation in this phase, I think it goes without saying that at this stage we have to collect and transfer evidence. And so we need tight coordination to be able to authenticate records, to get witnesses to be present during procedures. But I think I would also note that governments generally have stronger tools here. And so I think the coordination really must be first and foremost between governments. They're cheaper, generally stronger tools, but there can be distrust. And unfortunately, while civil litigation that I think Jean-Pierre mentioned at the beginning can be helpful, sometimes we see that private civil litigation on behalf of victim states can actually create complications for asset recovery through law enforcement because of, once again, contingency litigation funded through liquidation that are going after some perhaps of the most directly identifiable assets that can sometimes create unnecessary conflicts or unnecessary costs. And then finally, in the third area that I would highlight from the book is that there's a fair amount of helpful discussion about disposition and repatriation. And once again, I think some of these 3 or 4 areas that I've mentioned come into play. Evidence challenges, oddly enough, really remain even during the repatriation phase, because it may be that the country needs to demonstrate loss when in fact, some of the underlying crimes that may be proven are extortion or things that may not show necessarily a government loss. So there may still be needs for evidence gathering. I think the legal tools, there have to be mechanisms to ensure transparency, both by the repatriating countries and the receiving countries, so that the public can really see that their assets are coming home. And there are also some difficulties I think countries have in figuring out how to legally transfer assets. I would say that this phase is a surprisingly resource-intensive phase as well. And of course, building trust in this phase, once again, is important, and trying to avoid challenges from external actors that can undermine that process. So thank you.
Thank you very much, Dan. And you'll be happy to know that STAR will be publishing in the first quarter of the next year a paper on the enforcement of foreign judgments, because indeed that is an issue that is brought up a lot. And so we hope to provide some more research on that particular point. You mentioned also problems in coordination between civil and criminal authorities. So we'll now switch over to Rodrigo, who is such a civil practitioner. And maybe, Rodrigo, you can take up the issue of what are the challenges for you as a private practitioner. What do you see not working in Brazil? And then maybe later we can talk about how to resolve that. Rodrigo, you have the floor.
Thank you, Emil. Thank you, Jean-Pierre, for having me to participate in this such distinguished panel. In Brazil, I think, like the way it happens all over the world, there is several entities that went down, wind up, due to fraud and corruption, serious fraud and corruption that have been taking place in diverting assets of those entities, which shows that the system one time failed, was not able to prevent it, and it happened. And the situation that we face is entity owns with a debt of hundreds of millions of dollars, several creditors, victims. I'm working a case just now. We have 30,000 victims, and literally no assets to pay the victims. There is no assets in the entity. So this is a very serious scenario. And when you look for the persons of interest, the former controlling minds of those entities, the related parties, they still using their private jets, living at large, in the sense that what happened to the entity did not disturb it in any way the way of life of they were pursuing. In a situation like this, normally the court will appoint a trustee. And before we start talking about asset recovery, asset tracing, the trustee does have to mount the case. First, we have to identify what happened to the entity, to identify, establish a scenario where fraud and corruption took place. And that's a very burdensome initial task that the trustee has to accomplish. And that's very important because once you establish that scenario, we might reach a legal standing to start to pursuing the asset tracing. For instance, in Brazil, if you are able to show that the entity was abused, or that in the sense of patrimonial confusion, for instance, you are able to file for a pierce of the corporate veil, where you're going to hold liable the individuals that benefit from the fraud, or the corruption, let's say accidental crimes, or even extend the bankruptcy effect. And then you will have the legal standing to then start pursuing the case and start the asset tracing. And then you face several issues that you have to overcome, several obstacles that you have to overcome. First, and I think this is the major one, is that you are working for the victims of the fraud, the victims of corruption. So normally, I think Dan said that very well, is a position that you are short on money when you start to do that. You are short in cash, you are short in human capital. So you really do need to identify which scheme you are going to pursue to maximize the chances of recovering assets. You have to really be aware which battle to choose to fight, because if you take the wrong battle, if you take the wrong scheme to pursue, you might expend your resources, not be able to pursue the case anymore. So that's something that is very important when you are doing asset recovery, as starting to pursue the assets. And as you start and you're pursuing the assets, you start to data analysis, organizing where to go. On this type of cases, you deal with multiple jurisdictions. The entities in Brazil, but the offshore incorporated elsewhere who receive the money, the account is in another jurisdictions, and maybe even another real estate assets is in another jurisdictions. So you have to deal with multiple jurisdictions discovery at the same time, coordinating that. And afterwards, once you got the evidence, you have to coordinate the multiple jurisdictions litigation offshore, outside your country, and also in-house. So it is paramount that you can coordinate those strategies and those steps in order to maximize the chance of success. One thing that I have learned over these last 12 years is that us from the private sector and the authorities from the public sector, when you are aligned to fight to recover assets, we have to understand that we are at the same side of the table, and that we both, private sector and public sector, we do have strengths and we do have weakness each side. And if you combine those together, we are much stronger in order to tackle those who perpetrated the fraud. For instance, when you are within the civil venue doing the asset tracing, I think, I don't know if it was then or the former was talking about the burden of proof. But when you are proceeding with the asset tracing within the civil venue, the metrics of the burden of proof is preponderance of evidence, which means 50% plus 1. So if you are able to show that those individuals are in a way involved in the scenario of the fraud, you don't have to have a clear and cut beyond reasonable doubt evidence as is demanded in the criminal venue. You are able to seize, you are able to freeze and take this asset back. And from my experience over this last 12 years, I never had a case where we got a picture of the individual robbing the bank. You always prove your case by preponderance of evidence. Align all the facts, align all the evidence, and then you show that you have your case. So by the metrics of preponderance of evidence, by the burden of proof, the civil value is very strong. But on the other hand, the public authorities does have official channels. They are much stronger on that. And if sometimes there are some jurisdictions that is much more easier to get bank accounts information if you go through the criminal venue. But again, if you wait the criminal venue to really end up the litigation and forfeit the funds, it might take too long, or even you could face some difficulties. So if you do cooperate together on this task, you can both private sector and public sector, each one take the best of it, of each side. I think I'm stopping here, Emil.
Because you're already getting into the sort of recommendations a little bit. So I thought, before you give it all away, I'll pass to our next panelist and talk a bit more about international cooperation. Laure, you are the magistrate with the Ministry of Foreign Affairs and as such responsible for receiving and sending formal mutual legal assistance requests. But I know you also work on more informal routes of cooperation, and previous speakers have already mentioned the importance of international cooperation. So I was wondering whether you, from your angle, could talk a bit about the challenges in formal and informal international cooperation. Laure, you have the floor.
Sure. Thank you, Emile, and thank you, Jean-Pierre. Distinguished panelists, distinguished participants, wherever you are. First of all, thank you very much for giving me the opportunity to be panelist to this event, and congrats to STAR and the World Bank for this update of the handbook Asset Recovery. It's a very beautiful work and very useful for the asset recovery practitioners. Many challenges have already been identified by other panelists, so I will therefore be, Emile, quite brief. Well, in terms of challenges in asset recovery, I would like to emphasize a couple of things. One of the biggest challenges in asset recovery cases is the multi-jurisdictional aspect of the case, and therefore the international cooperation barriers. Excellent cooperation, excellent coordination between the jurisdiction are very important and are the key for the success of an investigation. And we know very well as practitioners that corruption cases and asset recovery cases are very, very complex. Criminal use, a lot of sophisticated schemes, kidnappers, lawyers, accountants, private sector, banks to disguise the illicit origin of the assets. On the other hand, in a few seconds and a click on your computer, money can disappear in another jurisdiction. And also, you know that some requested states are not responding. In fact, I think that there is no equality of arms between criminal offenders and prosecuting authorities. I mean, very often we have to chase racing cars with bicycles. That's very difficult. In this context, effective international cooperation with tangible result is very challenging. And as you know, the UNCAC Convention, or Article 51, the first article of the Chapter 5, specifies that state parties shall afford one another the widest measure of cooperation and assistance for the return of assets. In other words, the UNCAC Convention invites state parties to be proactive with a shared responsibility and a common interest. Crime doesn't pay. The proceeds of corruption must be confiscated, returned to their legitimate owner without delay. So I would like to emphasize 2 or 3 challenges in my professional life. First one, when a case involves more than one jurisdiction and that in addition the legal system are different, I mean common law, civil law, non-conviction based conviction, and criminal evidence, it's useful that the authorities from the different jurisdictions establish proactively contact yearly to understand the legal system of the other jurisdiction. For instance, the legal condition for mutual request assistance, the question of immunities, the degree of proof expected, and so on. Personal connection with foreign counterparts is important, and it's also the first step to build confidence. And this aspect is also very useful in the multi-jurisdictional cases. Building trust in international cooperation should simplify all the stages of an investigation, build a common strategy, and facilitate the return of asset phases. For instance, in my country, you can address an informal request to obtain information on the procedure to the Belgian ARO. What's the Belgian ARO? Is the Asset Recovery Office. For the requesting state, we have also a licensed magistrate at the Ministry of Foreign Affairs, and you can also use the channel to facilitate the personal contact. And I can give you, for example, the contact with the federal prosecutor, who is the prosecutor for the international affairs in Belgium. So I think that in this regard of the challenges related to international coordination and cooperation, use informal and personal contact at the early stage will improve the cooperation between the jurisdiction, and it's very important. And generally, when you have the good link, the good challenge, it's easier. Second challenge, the difficulty to exchange quickly the information between the practitioner. For instance, the identification and localization of an asset, the owner of a bank account. Those information are very important for the practitioner to use them and to make the puzzle to conduct the investigation and to go to the trial. It's also very difficult in corruption cases to get the evidence for the core. So Dana said that's an important challenge. That's the problem of the evidence and also the link between the asset and the criminal offenses. So how can we collect in a sort of real time this information? It's an important challenge, and I think, and it's what we done in my country, it's important to distinguish the informal assistance and the formal assistance with the mutual request. And it's important for us to use both informal and formal channel. For example, the informal assistance through a practitioner network like CARIN, ARI network, Europol, Interpol are very useful for practitioners to share in real time the information that can be available through a counterpart register. For example, police to police information, arrow to arrow information, you can share and you can have without sending mutual legal assistance some information like the owner of a bank account, the owner of a real estate, the localization of an asset, and so on. So those information are necessary for the practitioner to put together the pieces of the puzzle that will lead to the trial and the final order of confiscation. So next, the informal assistance. You have also the sending of the MLA request. As you know, the MLA request is submitted in writing and must be conformed to specified procedure. It's also a big challenge. Or is it possible to send directly with the good respect of the procedure, the good respect of the different parts of the MLA? Or can we use and send directly the good form of the MLA to the other jurisdiction? It's also important to use the national authority to have pre-MLA contact for sending the good MLA and not to have the return between the MLA. Just a word, Emile, just to say that the practitioner will find in chapter 8 and 9 of the book all the necessary information with references to cases about the main international cooperation that I have speak about. Thank you.
Thank you, Laure, and you were also going into the area of improvement, and so that's what we're getting into now. Going back to our first panelist, Willy, you talked a bit about the problems you faced at the beginning, the difficulties of bringing together different constituent parts in your jurisdiction, the idea for many, this is not really my job, it's not what I want to do. How did you manage to solve that? How did you manage to ultimately be successful? What were some of the main ingredients for you to achieve that? Willy. It looks like we have temporarily lost Willy. Okay, well, in the interest of time, let's then go on with you, Dan. Can you talk a bit about what has changed in the asset recovery practice in the last, let's say, 10 years, and since this has gone up the agenda so much, and what you think some of the most useful tools have been to resolving some of the problems you referred to in the first round? Dan.
I'm happy to go forward. I see that Willy has reappeared on the screen. I don't know.
Yes. Willy, sorry for this. ladies and gentlemen. Willie, wondering whether you can say a few words of how you overcame the challenges in the South African system, what you did to make sure that you were successful.
So, you know, our unit sort of started off in a blaze of publicity, and all the newspapers were very keen on what we were doing. But, you know, the reality is that it was the prosecutors and the police detectives who were doing the real hard slog work in many, many other cases. And I think what we did, one of the things we realized from early on is that those sort of ego issues matter quite a lot. You know, and so we kind of went out of our way when we did a case with the police to make sure that the senior police officer is there to take part of the credit for the work that has been done. And, you know, that we don't, I think we had a better or more professional capacity than most of the rest of law enforcement here. And, you know, so that in a sense, we put a lot of effort into working with our partners in law enforcement. And it was sort of wider than just the police. You may remember we had something called the Scorpions at that time. But also we sort of worked with quite a lot of other role players. For example, our Auditor General that does the audits for the whole of the state. They would often come across cases where there were clearly indications of criminality or at least malfeasance. So we tried to build quite a big network of other organizations in the state with whom we could work. But as I said, I think one of the important lessons there is, especially in a resource-scarce country like South Africa, I think in that process it is very important that one does give recognition as well to the people who help you with your cases, so that they can share a little bit in the glory that comes with the work in the early days, especially when it's still very interesting to everybody. I wanted to sort of raise one other issue, which I think is a wider issue, but I'm keen to hear from my colleagues in other countries. But one of the sort of big issues here with us is that a lot of money is put into trust, into family trusts. And in our system, there is no electronic system, for instance, on trust information. You literally have to go to the High Court and dig through boxes and boxes of files to find the trust documents. And so I think that's a sort of institutional issue that we've been fighting for 20 years now, to have a system where when wealth is put into a family or other kind of trust, that there has to be proper records of who the beneficial owners are of those trusts. So that is kind of one of the big issues, I think, that we learned. I think a second issue that several other countries have done that we haven't done is we don't have proper investigative powers for in our system, a curator, an independent curator from the private sector gets appointed to look after the assets, essentially. But they also play quite an important role in tracing assets that we may not have found. And in our system, they essentially have very limited powers. So if we could do it over again, and we're still agitating a bit for that, but I think the powers that insolvency practitioners have, which is that they can call people in and force them to answer questions, even self-incriminating questions, but those answers obviously can't be used against them in a criminal case, but it can be used to find the assets. So I think those kind of almost investigative type powers does become very important with people who have been sophisticated about how they've hidden away their assets. And I think a number of other countries have done that subsequently, but our laws here haven't been updated now for many years. It really needs a drastic update. But I do think that when one writes the law, one often forgets about the complexities of looking after the assets, who's going to do it, what powers are needed to track assets that the police or the investigative authorities may not have found. So I just wanted to make that point in a sense to that others can learn a bit from the omissions in our system in the early days.
Thanks very much, Willie, and very interesting the point you made about the Auditor General and altogether Cour des Comptes and similar type of agencies, whether it's a General Accountability Office or whatever, being brought into the fold can be very useful and are often forgotten when talking about asset recovery. Sorry, Dan. Going back to my earlier question to you, maybe you can take the floor now. Thank you.
Sure. Thank you. I don't think we have necessarily a solution to the trust issue. I think Willie's right that trusts and other legal structures, but trusts among others are a real challenge. I think there are instances, though, on that point where the legal structures themselves create problems for the public officials who are hiding criminal proceeds or their intermediaries, because sometimes they basically give away legal ownership to the properties, and that can be an opportunity for the governments in a confiscation proceeding to focus on the criminality of the assets, but it does still present some serious problems and challenges for tracing. I would say that over the last 10 years, we have seen significant changes and significant progress. And I think one area in particular is getting back to resources. I think there's there are much more resources being devoted to asset recovery and corruption worldwide than we've seen in the past. Like, it used to be a lot of attention and focus on asset forfeiture and asset confiscation was focused in the narcotics sphere maybe 20 years ago. But over the last 10 years, I think while there's still an important emphasis on disrupting those types of criminal organizations, I think we've now seen a heavy investment in corruption cases. In my own country, we have the Kleptocracy Asset Recovery Initiative that was started in 2010, where we have now dedicated prosecutorial resources focusing on this. And about 5 years ago, we got a dedicated FBI squad or group of squads that supports our cases, as well as our Foreign Corrupt Practices Act cases. And because of those and additional resources to the Office of International Affairs, I think that's made a real big difference in our ability to move these cases forward and investigate complicated cases. And that's just within the main Justice Department. We've also seen more cases brought by U.S. attorneys' offices around the country. So I think, at least in the U.S., there has been a significant investment in resources, but I have seen that also amongst our partners and raising the profile and the resources available to those practitioners, as STAR has done through this publication in the past, and the update today, I think, is really key to that. I think a second area where we've seen real progress is that there are more legal regimes for non-conviction-based forfeiture and other tools that have addressed some of the burdens of proof issues and brought some common sense presumptions to the process. I think Jean-Pierre mentioned unexplained wealth orders and things in other jurisdictions. I think, again, one of the other panelists mentioned the work of international civil society as well. I think we've seen a real impact by investigative journalists and non-governmental organizations that has been really crucial. In many situations, people who have knowledge of the criminality that's ongoing may be distrustful of local law enforcement and therefore may not have a way to bring that evidence out, whereas they may be more trustful of investigative journalists, and the work of these people, often very much on the front line, really can spur a criminal investigation where some of the threads have not necessarily been identified for law enforcement to pull on, particularly in another country. I think in some other areas where I think we've seen a lot of progress over the last 10 years is there is, I think, a growing emphasis on facts and evidence, and it's important, of course, to maintain the political pressure and the importance of establishing political will. But I think people are now, as the process has matured some, recognizing that it's not just an issue of we'd like to get back the assets of so-and-so, but it's trying to establish and do the real spade work of digging up the underlying evidence that will enable those cases to ultimately be effective. So I think worldwide, I think there's much more recognition of that. And as Laurie mentioned, the use of informal networks has been, again, a real boon to this process that has helped, work out both legal and factual issues, and whether it's through the Karen and Aaron networks or Egmont groups or sharing of financial intelligence. And then finally, I think I would say one other big change has been that investigations do seem to be expanding in the types of investigations that are involved. So where there may have been a focus on a particular criminal act, or now I think there is a coming together of different legal authorities to go after facilitators, people who may have been paying bribes, people who've been receiving bribes, and there's more, I think, coordination amongst agencies within countries. We've certainly seen that in the United States, but also between countries, where more bad actors involved in the process are being are coming into the investigation. So I think that's another product of some of the maturing of the asset recovery process. As a result, in the U.S., I think we've seen our numbers increase. We've, I think, recovered somewhere over $1.5 billion U.S. dollars worth of assets. We've returned and assisted the return of over $1 billion, $1.1 billion, and sometimes we don't actually forfeit the asset, but sometimes we can assist in the recovery of those assets as well. We're continuing to negotiate the return of several hundred million additional funds, and I think perhaps maybe more importantly, it's because some of it really depends on those kinds of numbers depend on the volume of the theft and the assets that are ultimately recovered. But I think we're also seeing that we've now been able to repatriate funds to benefit the people of Malaysia, Nigeria, Korea, Kyrgyzstan, Kazakhstan, and many others. And I think so. I think the number of cases has also grown as this coordination has increased. We've of course got over $1 billion currently restrained. We've got criminal charges now pending against individuals and at least one legal entity, and we've got convictions and plea agreements as well. And so I think there have been significant changes in a number of these areas. I think Laura also mentioned the challenges with respect to some jurisdictions that don't cooperate. I think we are seeing more countries that are cooperating, but yes, some of those challenges still remain that we, I think, collectively have to work to find a solution to bring some of those countries into the fold so that we can recover more assets for the benefit of the people who are harmed by this high-level corruption.
Thanks, Dan. Rodrigo, earlier on you were already giving some hints as to how things are improving in cooperation between civil and criminal practitioners, private practitioners and government practitioners, and there was a question from that in the chat as well. I was wondering whether you could say a bit more about how you can maximize your chances for success working with the Public Attorney's Office in Brazil, what you've been able to do there.
Well, I think Laura she was talking before about building trust. I think that's the starting point for the cooperation. And from the civil perspective, imagine attorney in the civil practice doing the asset recovery for victims of fraud in the civil venue, how he would trust the criminal prosecutors if there is a dispute between them where the asset will go, if you go for the state or you go for the victims. That issue was solved in Brazil in 2011. We had a case called Banco Santos case, is a very well-known case. And the public prosecutors did a great job, the Brazilian prosecutors with the United States, and they were able to forfeit artwork in the US. And then the bankruptcy state, which I was representing, wanted the artwork in order to pay for the victims. And the federal prosecutors, they wanted it for the state. And this question ended up arriving at the highest court for federal matters in Brazil. And the third chamber ruled that the proceeds of the forfeiture has to go to pay the victims of the insolvency. And that was a very important decision, in my perspective, the way I see it, because now we are very comfortable in holding hands with the public prosecutors and work together, really building a team. And that actually happened. For instance, in 2018, we had a case that we needed to collect information in Switzerland. We were in insolvency proceedings, and we knew that if you go through a criminal proceedings, it would be much more faster, much more smooth to get information. So we had a hearing with the public prosecutor in Brazil for the criminal venue. So listen, there is indicators of crime. Let's work together on this. Let's get information. So the public prosecutor opened the file. We, from the civil venue, we hired a lawyer in Switzerland. He helped us to draft the MLAT, so it will be perfect with no going back and forth. The public prosecutor in Brazil sent the MLAT through the official channels. We did informally as well through email to the Swiss authorities, say, listen, you are going to receive an MLAT regarding those accounts. There's something fishy going on there. And the result of that, might not appear to some people fast, but for us was very fast, because within 6 months, we got all the financial statements and now the bank account frozen. And that was a very good start for the case, because we spent very little resource from the victims, because the prosecutors was with us, using the official channels. And that was very fast, agile, and we were able to deliver some results for the bankruptcy state, for the insolvency state, who was victim of fraud and corruption in relation to the diversion of assets. So that's my contribution here, Emil. I was not going to spoil when I was talking. I wasn't stopping there, but I was having this to accept that I wanted to deliver to you.
Thanks very much, Rodrigo. That's a very positive example of how the two can indeed work together. And you mentioned there, almost by the by, the fact that you managed to minimize cost doing it that way. And that's, of course, a very important consideration when you're talking about hiring private counsel. So finally, Laure, you already went some way into extolling the virtues of informal cooperation to make sure that mutual legal assistance works. I was wondering whether you could say a few more words, and then I'll throw it open to wider questions. Laure.
Yes, Emile, thank you very much. My internet is very low, so I close my video at this moment. Let me speak about maybe a specificity of the Belgium, and it's the Belgian approach to foreign bribery, if it's possible, and more specifically the corruption of foreign public officials. I will speak with a few words on the problem of grand corruption and how we can better detect grand corruption cases. As you know, one of the main challenges, and it's emphasized by Transparency International in its report Exposing Corruption, one of the main challenges is the detection of the grand corruption cases. Of course, we have the very good works of the investigation journalists, the works of whistleblower and so on. But how can we better detect corruption case on the public side? And that's the Belgium reflection. What's the Belgian approach? We need first, of course, a robust normative network. First, the criminalization of transnational bribery, whether it's committed by natural or legal person, exists in Belgium since 2007. That's not a problem. Secondly, our legislation allows the prosecution of Belgian company, of Belgian person who have committed acts of corruption abroad. So we have the extended extraterritorial jurisdiction. That's not a problem. We have also in our legislation another very interesting disposition, and you can find also this disposition in Article 8.4 of the UNCAC Convention. And what is the goal? In Belgium, any civil servant abroad or in Belgium or any public official has the obligation to report to the judicial authority any crime or any offenses of which they become aware in the performance of their duties. This obligation is part of the Belgium's national integrity system. But despite this optimal legislative framework, the international anti-corruption evaluation and the evaluation from the OECD emphasized that there were no cases for large-scale foreign bribery opened in Belgium. And of course, Belgian companies are also subject to corruption risk, especially in the countries where corruption is endemic. So we decided in 2015 to change our approach in a proactive way, and we establish a public mechanism for detection of suspect foreign bribery case and a channel for reporting such cases, a public channel. The mechanism is based on three pillars. First, the Belgian diplomatic post, and secondly, the Ministry of Justice and the Ministry of Foreign Affairs. The network of diplomatic posts abroad. As you know, diplomats and officials of diplomatic mission are likely to receive some sensible information. For instance, a PEP who has been corrupted or other sensitive information, and they are also generally very familiar with the business climate in their jurisdiction. On instruction of the Belgian Foreign Minister, which is addressed to them, to the diplomatic post on 9 December. 9 December is the International Anti-Corruption Day. all diplomatic posts are reminded of their obligation to make Belgian companies aware of the risk of corruption in the country and the rule of integrity in business, but they are also reminded of their obligation to denounce any indication of alleged corruption on the part of a Belgian company. So concretely, yesterday, on the occasion of the anti-day corruption, Sophie Wilmès, who is our Minister of Foreign Affairs, sent an instruction to all diplomatic and consular posts in the world so that in their work relation with Belgian company in their jurisdiction, they raise awareness on this prevention and on their obligation in terms of due diligence and reporting. And let me say, Emile, that since 2015, several cases, 10 cases of grand corruption have been reported to the Ministry of Foreign Affairs, and I have reported these cases to the Ministry of Justice, and now the cases are open to the Federal Prosecutor. Two important cases concern the exploitation of resource in the mines, so gold and all mineral, cobalt, and so on. And the corruptors are Belgian companies. Of course, there are some investigation, for example, the report of Century, who has pointed the role of the Belgian company, but without the connection between the diplomatic post, the Ministry of Foreign Affairs and Ministry of Justice, I'm sure that never the case will be open in Belgium. So I think that, in my view, it will be very important to strengthen this culture of judicial diplomacy and to use diplomatic networks in a global approach of fighting impunity. And maybe we could dream, we could also even a day provide and hope for exchange of information between diplomatic posts of foreign jurisdiction. Maybe some words, Emile, if you permit it, on the EU framework. I think it's also very interesting for the participant. As you know, probably the EU members have set up some inter-coordination agency for transnational investigation. Some words about those agencies. You have of course the Camden Asset Recovery Interagency, so the CARI network, and Belgium has the presidency of CARI this year. CARI is an informal network of contact points and of cooperation group in all aspects of work for law enforcement taking the proceed of crime. The aim of CARINS is to increase the effectiveness of member efforts on a multi-agency basis, deprive criminal of their illicit profit. So what are the main objectives? Establish a network of contact points, so you can use direct contact and build confidence and trust, focus on the proceed of all crime, promote the exchange of information and good practices, and encourage member states to establish national recovery office. CARIN can also facilitate MLA on seizure confiscation of assets. Another important agency is Eurojust. Eurojust is for the magistrate and the prosecutor. Eurojust is an EU agency that offers tailor-made operational support for cross-border criminal investigation, providing, for example, links to key counterparts, assistance with the preparation of judicial cooperation requests, and more interesting, this agency can coordinate parallel investigation, can also organize coordination meeting, and very interesting for all the practitioners, set up or fund joint investigation teams in which judicial authorities and law enforcement from different jurisdictions work together. It's very, very important. And we have also Europol. Europol is, of course, the European Union laws enforcement agency that assists the EU member states in the fight against serious international crime and terrorism. And the core business of Europol is the exchange of information police to police. Since that's my last intervention. Since a few months, we have also the European Public Prosecutor. It's completely new. It's a big challenges for the European member. So the European Public Prosecutor, it's an independent and decentralized prosecutor office for the EU that will coordinate its action with Eurojust, Europol, and Olaf. So what I would like to mean is the coordination and the cooperation, the joint investigation team, and the possibility to work together is very, very important and can be a good practice that can be used in other regional networks. Maybe one day an African, not Eurojust, but Africa just. Why not?
That's a nice idea and a good good goal to aim for. More regional networks that focus on the recovery of proceeds of corruption. Thanks very much for that, Laure. Both Dan and Laure mentioned the role played by civil society in uncovering possible corruption and the importance of that sort of information channel. And I was wondering whether finally I could call on one of the co-authors of the book, Natasha Sotiropoulou, who's also on here, who maybe can give a bit more of a insight into the role played by civil society in uncovering corruption and the importance of civil society. That's because I think we would be amiss concluding this panel without dedicating some time to that. Natasha.
Thank you very much, Emile. Thank you very much, Jean-Pierre, for the opportunity to participate in the update of the Asset Recovery Handbook. Indeed, it was mentioned by the panelists, it was mentioned by Jean-Pierre that the role of civil society organizations in asset recovery is increasingly significant. Their importance is recognized in the United Nations Convention Against Corruption. In Article 13, states parties should promote their active participation in the prevention and the fight against corruption. Civil society organizations, they give citizens a voice, they demand greater transparency, and they contribute to a culture of integrity and accountability. They have traditionally engaged in the asset recovery process through raising awareness across society, through research and advocacy. And most importantly, and most recently, they have assisted states in their enforcement efforts to identify and investigate corruption cases by collecting and verifying and exposing information, by cooperating with investigative journalists. They have provided advice and they have supported whistleblowers. They have been the recipients of returned assets. They have monitored the asset recovery process and they have brought legal actions. So what we try to do in the handbook is to specifically refer to certain cases where civil society organizations have actively participated in the asset recovery process. To name just a few, the Bian Malaki case, for instance, that shows how a report by civil society organization revealed information about the assets of 23 dictators and led to the initiation of criminal proceedings in France. An NGO with an anti-corruption mandate filed a criminal complaint with a civil party petition against the presidents of 3 countries, their close associates and families. The complaint was joined later by TI France. Legal standing was an issue there, and it was later found by the court that indeed there was legal standing. So this is one leading decision that we have out there. Another case that is mentioned in the handbook is the Bora Foundation, and we demonstrate there how a non-profit, non-governmental foundation was assigned with the task to manage and use returned assets for the benefit and support of the citizens of Kazakhstan. So these are two cases that demonstrate that responsible repatriation via civil society is possible, and they can have a significant role in the asset recovery process to the extent possible and permitted by law. And these are two important examples that have worked in other countries and may also work in ours or in other countries. And this is what we try to do to show in the handbook, that we don't always need to invent the wheel. There are best practices and examples out there, and they can inspire the tools and the mechanisms that may be used by other countries. And I think that the handbook demonstrates that as best practices. Thank you.
Thank you very much, Natasha. Yeah, and to one further point on how third parties / civil society can be successful and can actually have standing before the courts to open corruption cases. Just yesterday in the Netherlands, at the moment the decision is only available in Dutch, so it's not much point in sharing it. But just yesterday, a foundation protecting shareholders' interest was successful in asking the High Court, the Appeals Court in The Hague, to open an investigation it ordered the public ministry, so the public prosecutor, to open an investigation, a criminal investigation, against Ralph Hamers, who was the CEO of ING, who's now the CEO of UBS. So, you know, this is not small fry. This is very high public profile for money laundering. There's been a lot of complaint about, banks and others are getting away with too much, and the banks pay the fine, which ultimately means the shareholder suffers, but there is never any personal responsibility. Well, this is one example where a third actor, as I say, a foundation protecting shareholders' interests, was successful in at least ordering the opening of a criminal investigation against the CEO. So another example of others intervening. We have gone over time. I had said at the beginning that I would ask the panelists to give in one line or one reform that would be, and I apologize that we haven't really been able to get into the questions you raised. I'm just looking through it now. Right at the beginning, there is a question from Mays on exploring blockchain technologies for asset authentication practices. Dan, I wonder whether you could say a word or two more generally about the role of transparency in asset recoveries and in asset protection. Asset tracing. Maybe could you pick up this? So this is the question right at the beginning of the chat on using blockchain technologies for asset authentication purposes. Yeah.
Sure. We don't, as of yet, have an experience where we've used blockchain to facilitate repatriation of assets to benefit the people of the country harmed by the corruption. We are looking at that as a possibility. We do think that it's crucial in asset recovery cases that there be transparency and accountability in a successful repatriation, and technologies that promote that may be able to provide a really useful service. It's certainly having external monitors and external auditors are another way that is important. Having defined end uses so that funds go to a particular observable project or benefit to the country also can really increase the anti-corruption impact and message, so that the wider public can really see the funds coming back and being used to benefit their communities, rather than sort of going into the mysterious void of a government treasury. And so I think it's an issue that we are looking at, but it's not something that we've had experience with specifically with blockchain.
Thank you, Dan. We are now 8 minutes over time, so I apologize. I realize there are a few more questions in there that I couldn't get to. Last question on the Dutch case, I just put a link in the chat so that you can see. But as I say, I think at the moment the statement, the court decision is only available in Dutch, but there should be more publicity on this forthcoming. I'm pretty confident, but this is a short link. Final word for each of the panelists. If you could force one measure, one reform, nationally or internationally, to improve asset recovery, what would it be? Willie, can we start with you?
I've got a slightly out of the ordinary idea, but we in South Africa at various times have used a technology called voice stress analysis that can basically determine whether somebody is telling you a lie or not. And my out of the box idea is when you question, when you have frozen assets, you often do need to ask the owner of those assets, or the criminal basically, to make a truthful declaration of their assets. And I thought the use of a tool like that in discovering the location of assets may be a proper out-of-the-box idea.
That is certainly an out-of-the-box idea, and we like out-of-the-box ideas, because without those, one is not going to make any progress. But voice tracing analysis for income and asset disclosure, that's a great one, and one I haven't heard before. So great. Thank you very much, Willie. Dan, what is your big idea?
Well, I'm going to sneak in a second one because of part of the discussion, but and some of the comments in the chat. I think elimination of success fee and contingency fees in this area is really important. I think there's a lot of conflict that's unnecessary, where different victims are competing over the same assets, and they're sometimes competing with governments. We've even had governments litigate against us when we've been trying to assist in the recovery of assets. So I would be very concerned about an expansion of success fee and contingency fee relationships. So that would be my extra one I would throw in. What I was going to suggest is that perhaps similar to what the theme of Willie's suggestion is adoption of prevention measures with criminal penalties. I think those can be really useful in investigations, both for identifying and through identifying assets and deterring criminal conduct, but also because if you get a false statement on one of those, you can really use that to your benefit in showing the criminality. And sometimes that can be very useful, particularly where you have a false statement to a financial institution or a false statement by an intermediary who is setting up these structures. Those can be very helpful to jurisdictions that are trying to assist but may not have direct access to the underlying criminal conduct. So that would be my area of emphasis.
Thank you very much for that, Dan. Rodrigo, your big idea.
All right, I'll be very brief. I know you are short on time. My goal would be change the Article 43 of UNCAC in the sense that the party states shall cooperate not only in criminal issues but also in the civil venue if you are tracing assets originated in criminality. So it doesn't matter if you are going in civil venue or administrative venue. If you are asset tracing, if you're pursuing assets originated in criminal activity as corruption and fraud, the party states would, I think, not only be encouraged, but shall assist each other. That would be a change game in my view.
Thank you very much. Changing shall consider. I'm just taking my copy of the UNCAC here. So not just encouragement, but actually mandating states to cooperate when it comes to criminal tracing. Thanks. And then finally, Laure, what's your big idea?
Yes, thank you, Emile. Very briefly, I put one ID in the box ID. I think that it should be very interesting to support a global register, a global and public register for beneficial ownership. That's my idea. I think it's also an idea and a discussion with in the FACTI panel, but I think it should be a very good challenge and a very good idea. Maybe in 10 or 20 years, I don't know, but go.
Again, a very big idea and indeed a big request also from civil society, and an idea that Gabriel Zuckman and Thomas Piketty and others are strongly supporting. With those big ideas and novel insights, thank you all very much. Jean-Pierre, as the lead author, I think it is only fitting that you have the last word on this. Closing words from you.
Thank you, Emile. That's very nice. I think I have not been disappointed by this panel. Definitely, a lot of strong, dynamic, and new ideas actually. So we can start immediately to prepare the update for in 10 years or of the next update of the book. But for me, my main two ideas of that should help asset recovery in the future. I come back to my two ideas that are really key to me, and this is the role of civil society first. And actually, there are also questions about how to help civil society continue this action. So that's another axis for action, helping civil society play this role. And the second thing is extending as much as possible these laws on unexplained wealth orders, or however we can call them, that help ease the burden of proof in corruption cases, and specifically in confiscation cases. Thank you, Emile, and thank you, everybody, for this great discussion. Thank you.
Thank you all very much. Thank you, panelists, and thank you, audience, for your engagement and for staying on for so much longer. And we look forward to your remaining engaged. We will launch our new website, the new STAR website, next month, and hope to be able to remain in touch with you in that way. Thank you all very much. Bye-bye.